morning, everyone. If you'll take your seats, we'll get started. Thank you. Today's Tuesday, May 16th, 2023. It's 9 o'clock. We are here in council chambers for the hearing examiner hearings today. I'm calling them to order at this time. Before we start with the first hearing, I'd like to introduce our process. The process that's followed here in Cape Coral is a little bit different than the process that's followed in other jurisdictions. In our process, the clerk will read the introduction to the case, and then she will swear in anyone who is testifying as to that case. City staff will then testify regarding compliance with public notice. If public notice has been found, the hearing will go forward. If public notice is not found, then we will take another route. Assuming the public notice is found, the applicant will go first and present their entire case. City staff will go second and do the same. Public comment is next. If you're here for public comment, we will ask you please to fill out a card. Actually, they're a sheet of paper. Look like this. They're available at the corner of the dais as you walked in today, or available from our clerk. The purpose of that is so we can spell your name correctly. I also have a number of emails that will be addressed in the appropriate hearing. But if you are here for public comment and you wish to speak and you've not filled out a card, don't let that deter you from speaking. You can certainly speak and then fill out the card at another time, hopefully today. The reason I say that is if you're here for public comment, please make sure that your comments are comprehensive, because once public comment is closed, it will not be reopened. And I would ask you, if you're here for public comment, there is a separate microphone and lectern at my left, your right. Well, some of your rights, some of your lefts. And I would ask you to speak at that. It's really for your protection, the health and safety of you and everyone else. The applicant and and staff will use the other one, and they're exactly the same. They have the same audio and video capability. In any event, following the closure of public comment, the applicant will respond to questions, make any final comments, staff will do the same, and then the hearing is concluded. If you have a cell phone with you today, please turn it off or silence it if you can. And if possible, if you want to engage in conversations on your cell phone, please take them outside the room. In addition, if you wish to have private conversations, please move away from this lectern so we do not accidentally record your conversation. If we do record your conversation, whether it's on a cell phone or otherwise, while you're in the chambers here, your conversation becomes public record upon being recorded. If you have comments, please come to the lectern so we can properly record your testimony. No testimony will be allowed from your seat. That applies to the public, staff, and to the applicants. And I covered that. And also, I just want to make a personal comment. I have received a number of emails regarding one of our hearings today, as I've already alluded to. My philosophy as a hearing officer is to listen to everyone, and I expect everyone to be respectful of everyone else. I will listen to you as long as you wish to speak. We don't have a 3-minute limit, but in exchange, I would ask you to be courteous to anyone else who is speaking. If they don't agree with you, this is America, we're a democracy, and my job is to listen to everyone. So with that comment, I'm going to ask our clerk to call the first case. If you have a copy of the agenda, we are hearing the cases out of order today. As a courtesy to one of the applicants, we're going to be hearing case B first, which is VAC 22000034 first, and then the rezoning will come second, and then the VAC 22000033 will have its place as last on the agenda today. So with those comments, as I indicated, I'm turning it over to the clerk to call the first case. Thank you.
Case number VAC 22-000034, address 5414 and 5418 Southwest 3rd Avenue. Applicant Mark and Valerie Perusitis. This vacation was initiated by the owners of property at 5418 Southwest 3rd Avenue. The owners plan to construct a new home on the site. They are requesting to vacate 2,000 square feet of street right-of-way and 708 square feet of platted easements on a hammerhead cul-de-sac between their property and 5414 Southwest 3rd Avenue. The vacation will enlarge the area of both properties. The vacation will provide the owners of 5418 Southwest 3rd Avenue with greater flexibility in designing and constructing a new single-family home on the site. Underlying easements in the vacated right-of-way will be retained by the city. Any persons wishing to speak during public, any persons wishing to speak, please raise your right hand. Sorry, I grabbed the wrong thing. Any persons giving testimony today, if you are able, please stand and raise your right hand. Do you solemnly swear or affirm to tell the whole truth and nothing but the truth? Thank you.
Thank you, Madam Clerk. Good morning, Mr. Heller.
Justin Heller, Senior Planner with the Cape Coral Planning Division. I wanted to testify that this case was properly noticed with a sign posted on the property, mailing sent out to all property owners within 500 feet, and an ad run in the local newspaper.
Thank you. We'll find the proper notice was given. Thank you. May we have the applicant's representative up, please? Thank you. Good morning, Mr. Hertz.
Good morning, Madam Hearing Examiner. My name is Scott Hertz. I am here on behalf of the applicants, Mark and Valerie Persades. I'm okay, I'm good. I was just gonna display that. If we could switch to that one. Thank you. My clients are Mark and Valerie Persades, and I'm here representing them. They're the owners of 5418 Southwest 3rd Avenue, Cape Coral, Florida. They're the ones, as you heard in the introduction, that initiated the application with the agreement of the adjacent property owners located at 5414 Southwest 3rd Avenue. David Little and Holly Steves, who joined in the application. The resulting of this, and we're about to put it up on the screen. I'm sure you've seen the graphic, but I was going to put up on the screen. This is what's commonly referred to as a hammerhead area off of a cul-de-sac, as occurred in many areas in Cape Coral, that is not serve any public purpose or use. It is not used as part of the public right-of-way. The cul-de-sac is in existence. The roundabout, for lack of a better term, at the end of the cul-de-sac, the circular drive that we're trying to get up on the screen for you, but was included in the staff packet, will remain, and vacating the hammerhead will not affect traffic circulation or access to any property or driveway. Additionally, as you heard in the introduction, to facilitate this process, we're only vacating the right-of-way portion of the easement. The public utility and other uses will remain in the underlying easement. My clients are going to remove the existing asphalt by agreement, which is one of the suggested conditions from city staff, and my clients have agreed with that, to remove the asphalt, place sod in that area, and as well as there is a stormwater catch basin that is in that area, just in front of, in fact, when you look at the photograph, if you see the white car just in front of it and to the left of it where the vegetation is, in that area, there is currently a stormwater catch basin. The city has requested that be brought out to what will be the new edge of the property to facilitate access to that. My client has agreed to do that and bear the costs of it. One of the reasons there's a little bit different condition is the city has not yet figured out the exact design of the swale and the cut sheets they'll have to prepare. So one of the conditions that we have agreed to is that upon the city stormwater staff determining exactly how they want the swale to be done in the exact location of the catch basin, we've agreed to put the catch basin in that location and comply with those requirements. And that's a condition that we have no issue with, because it's just not possible to do that engineering at this time until after we're further along in construction, as is normally done with these types of homes. The property being vacated will be split 50% between my clients and Mr. Little and Ms. Steves. Vacating this land will return the land to the tax rolls and improve the city by enabling full development of these parcels, thus increasing the value of the land and taxable income to the city. As we discussed, as the easements are being maintained, and all three of the utilities at issue, LCEC, Comcast, and CenturyLink, have all provided letters stating they have no objection to this. I believe, LCEC just wanted to ensure that the 6-foot perimeter easement would be maintained around both the properties, which, as you can see from the enclosed sketch and descriptions, we have provided the sketch and descriptions for that, and that will be done. So there'll be no negative impact to the city or any of the adjoining neighboring properties. Again, this sort of current right-of-way design, this has been done many times to make use of this hammerhead area that is no longer being used. There won't be any detrimental effects. It's all positive in terms of the individual factors that are to be considered. The city staff analysis has agreed that this area is not being used by the city, and the city has no future transportation, access, water management, or public utility purposes necessary for the road portion. I want to be clear on the public utility purposes, since we are maintaining the easements. If the city does have any public utility needs for the area being vacated, there's still an easement being maintained over the whole area being vacated, so that doesn't impact it in any shape or form, and the city will still have full access to that area. And the right-of-way vacation will not eliminate access to any properties, as the circular portion of the cul-de-sac will still give access to all of the existing properties as well as the new home to be built. No alternate routes are required, as doing this, the state of the cul-de-sac will remain, and the local utility providers have given their consent. We do believe this is in compliance with the comprehensive plan to encourage these types of developments, and it is consistent with the use of single-family homes. It has been done in many similar locations throughout the city. City staff did suggest a number of conditions that I'm sure Mr. Heller will walk you through. I have reviewed them all, and on behalf of the applicants, we agree with the proposed conditions. I stand ready to answer any questions you may have at this time, but that completes our presentation.
Thank you. Do you wish to incorporate the staff report into your presentation as well?
Yes, ma'am, we do.
Okay, thank you very much. I have no other questions. Mr. Heller, thank you.
Good morning again, Justin Heller, Senior Planner with the Cape Coral Planning Division. This is, as previously discussed, a vacation of right-of-way located between 5418 and 5414 Southwest 3rd Avenue, particularly 2,000 square feet of street right-of-way. In addition to that, they'll be vacating 354 square feet of platted easements, lots 41 and 42, and an additional 354 square feet of platted easements in lot 43. The vacation will enlarge the area of both properties. It will give the owners of 5418 Southwest 3rd Ave greater flexibility in designing and constructing a new single-family home on the site, which they are currently in for permitting. The adjacent owners have provided a letter supporting this vacation request. They did stipulate that they would like the pavement and sod in that area removed, which the applicants have agreed upon. This was also a condition that the city has proposed. Both properties do have single-family R1 zoning, as well as single-family future land use classification. Here's the exhibit. I think Scott covered pretty well. It just highlights the approximate area where the vacation will occur. So our analysis, we look at the standards in section 3.4.5b. The first is whether the easements are required by the city for any future transportation, access, water management, or public utility purposes. The city does have a stormwater pipe in the right-of-way. However, all underlying easements in that right-of-way will remain. The applicants have agreed to remove the existing pavement, sod this area, extend the drainage pipe, and install a new catch basin in the right-of-way, basically with the approval of Public Works as far as the exact locations of those go. The platted easements in lots 41 to 43 will also be vacated. These easements, however, are not needed by the city because we will retain perimeter easements around each site with a minimum width of 6 feet. Here's a more detailed sketch showing the exact area to be vacated. It also shows the existing catch basin and the proposed removal of asphalt extension of that catch basin out to the right-of-way. This again is just an example of compliance, and per Public Works, the exact locations may vary once they take a look at it. So our second standard, whether any required easements are necessary to accommodate the vacation of any plat, easement, or right-of-way. Again, these easements underlying the right-of-way are going to remain. The city will also retain 6-foot public utility and draining easements around each new expanded site. Number 3, if alternate routes are required or available that do not cause adverse impacts to surrounding areas, we find that the cul-de-sac itself is not going to be impacted by this vacation request, so no alternate routes will be required, and this vacation will not have adverse impacts to the surrounding area. Number 4, the closure of a right-of-way. If the closure of a right-of-way negatively affects the areas utilized for vehicles to turn around and exit an area, again, the vacation is not going to impede the ability of vehicles to use that cul-de-sac and turn around and exit the area. Number 5, whether the local utility providers have given consent to the vacation of the plat easements or right-of-way. All 3 utility providers have provided letters of no objection. LCEC does require a continuous perimeter easement provided around each expanded site. The city agrees with that. CenturyLink and Comcast also stipulated that if facilities are found or damaged within the vacated area, that the applicants will bear the cost and relocation and repair of said facilities. This is part of our conditions of approval. In regards to our comprehensive plan, this request is consistent with policy 1.15 that identifies R1 as being consistent with the single-family future land use classification. We find it's also consistent with policy 1.15A. The site will be developed with a density less than the maximum of 4.4 dwelling units per acre allowed within the single-family future land use classification. And the Cape Coral Planning Division is hereby recommending approval of the requested vacations with conditions. And I'll walk through those conditions now. Okay, the first condition, the vacation of 2,000 square feet of right-of-way shall be consistent with the sketch and accompanying legal description prepared by Harris Jorgensen, LLC, dated August 31st, 2022, entitled Exhibit A. The second, the vacation of 354 square feet of platted easements in lots 41 to 42, block 188, shall be consistent with the sketch and accompanying legal description prepared by Harris Jorgensen, LLC, dated March 17, 2023, entitled Exhibit B. The third, the vacation of 354 square feet of platted easements in lot 43, block 188, shall be consistent with the sketch and accompanying legal description prepared by Harris Jorgensen, LLC, dated March 17, 2023, entitled Exhibit C. I do have copies of all these exhibits for you as well. Number 4, the city shall retain the easement sufficient for maintaining a minimum 6-foot wide public utility and drainage easement around the perimeter of each expanded site. Number 5, if utilities are found and/or damaged within the vacated areas as described, the applicant will bear the cost of relocation and repair of said facilities at the sole discretion of the affected utility provider or providers. Number 6, prior to the issuance of a certificate of occupancy for a new house at 5418 Southwest 3rd Ave, the owner of the site shall move or replace the existing stormwater pipe near the property lines of lots 42 and 43 and extend this pipe to a new inlet constructed within the city right-of-way. The relocated catch basin shall be reconnected with the existing stormwater management network by a like size and material storm pipe. At the sole discretion of the city, the applicant shall grant all necessary easements for any new or modified stormwater system if required. All improvements shall be inspected by the city prior to the issuance of a CO. Additionally, the pavement associated with the vacated street right-of-way shall be removed from each site. This area shall be sodded following the removal of this pavement. The cost of all improvements identified in this condition shall be borne by the owner of lots 41 and 42. And lastly, Exhibit D is a proposed example of compliance with Note 6. The exact design and location of the drainage system is subject to change within reason to accommodate future use, and that will be determined by Public Works Department. That concludes my presentation. I stand by for any questions you may have.
Thank you. I have no questions. This is a public hearing. Are there members of the public who wish to provide input or testimony regarding this hearing? Seeing none, I'll bring it back to the applicant's representative. Mr. Hertz, I noticed in the last condition that Mr. Heller referenced, there's a, it seems a little vague to me. He referenced that Public Works would make that determination. Is that acceptable to you?
Yes, ma'am.
All right, I have any other testimony?
No, ma'am, and that is how it's standard, when single-family homes are built, that's how it's standardly done. It's towards the end of the process that they provide that information to the builder, so it's really in accord with how you normally do it.
Okay, fine, just wanted to make sure you were on board with the language.
We are in agreement, thank you.
I appreciate that. Mr. Heller, anything else?
I have nothing further, thank you.
All right, fine, thank you very much. I will recommend that the vacation go forward as requested. I know time is money, so I will attempt to get the recommendation out as quickly as possible. Closing this hearing, and Madam Clerk, the next hearing, please, thank you.
Case number RZN 22-000029, address 2810 through 3000 Southwest Pine Island Road. Applicant, Lee Memorial Health Systems, 2900 Honk LLC, 2950 Honk LLC, and 3000 Honk LLC. The applicant requests a rezone from agricultural AG2, a Lee County designation, to commercial corridor CC for 5 parcels totaling 41.7 acres. The site was annexed into the city of Cape Coral in 2022. The future land use designation was amended to Pine Island Road District in April. The rezone will allow for commercial mixed use or multifamily with restrictions along Pine Island Road. The rezone is the last step to allow for development at this recently annexed site. Any persons giving testimony today, if you are able, please stand and raise your right hand. Do you solemnly swear or affirm to tell the whole truth and nothing but the truth?
I do.
Thank you.
Good morning, Mr. Boyko.
Good morning, Madam Hearing Examiner. Before the applicant gives their presentation, I just want to let you know that this case has been properly advertised. There was a sign posted on the property. There were letters sent to property owners within 500 feet of the site, and there was an ad placed in the newspaper for local circulation, and all of this was done prior to 10 days before the public hearing.
Thank you. I will find the proper notice was given.
Thank you.
Good morning. May we have your name for the record, please?
Sure. My name is Christine Fisher, and I work for Johnson Engineering, and we are representing today Lee Memorial Health Systems and Honch. As mentioned, this involves 5 properties along Pine Island Road. 3 of these properties to the west are owned by Honch, and 2 are owned by Lee Memorial Health Systems. It totals 41.73 acres. It's bounded by Sandoval Parkway on the east, Southwest Pine Island Road on the north, Royalty Circle on the south, and Royalty Boulevard on the west. As mentioned, the property was voluntarily annexed on November 2nd, 2022, and went through the process of being assigned the Pine Island Road District Flume designation in March of this year. According to Section 1.10 of the Land Development Code, all annexed lands in accordance with State Statute 171.062 comes into cities with the county land use and future land use and zoning designations until the city takes action to change those to city designations. At this time, we are requesting that the commercial corridor zoning district be assigned to these properties. Current uses on the property for the parcels are currently undeveloped. One of the parcels owned by Honch includes an 820 square foot construction office that was built in 2003 and outdoor storage that has been actively used for several decades for this type of use. The surrounding parcels include some vacant parcels, single family on the south and to the west, multifamily to the east, commercial along Pine Island Road, and further west along Pine Island Road, and a gas station. The Lee County zoning map, adjacent zoning districts include RS2 to the south and Commercial 1 and AG to the east, west. Those are in the county. And in the city, everything surrounding it that does abut is zoned commercial corridor. Designating the subject property as Cape Coral Commercial Corridor is consistent with the designation of adjacent parcels along this corridor, and it continues the zoning pattern along Pine Island Road. We do find that the rezoning is consistent with the comprehensive plan, as it is the only zoning district that's compatible, conventional zoning district that is compatible with the PIRD future land use designation. It abuts an existing and developed corridor zoned area. The CC designation is across the right-of-way to the north and the east and also further west. It abuts the corridor with this CC zoning on 2 sides or more. To north, again, across southwest Pine Island Road and east across Sandoval Parkway. It is not part of a larger tract that is already zoned corridor, but it is a large tract as it is. It is an assemblage, as I mentioned, it is a large lot assemblage of more than 3 acres, and it fronts on Pine Island Road for at least 180 feet. It actually is 1,500 linear feet across Pine Island Road. The full range of uses that are allowed in the proposed zoning district is compatible with the existing uses along the corridor. It allows a wide variety of uses that would be compatible. If there are any potential neighborhood compatibility issues, they will be mitigated through compliance of the Land Development Code. Allowed uses in the CC district are similar to existing uses along the Pine Island Road corridor. Future development of the property in the surrounding area will likely be similar to this. There is some, as I mentioned, there are some single-family lots that exist to the east and the west and to the south, but there's already a substantial amount of commercial in the area. The 4th criteria, it does serve a community need or a broader public purpose. Cape Coral has long identified and recognized that it has a deficiency in commercial land. The Pine Island Road Corridor Master Plan also envisions this area as part of that corridor district to include a range of compatible uses that connect those districts. The size of the subject site with frontage on the major arterial also provides this opportunity for additional commercial mixed use and other uses that are compatible with the district. The proposed 5th criteria, the proposed rezone area is suitable for uses permitted in the proposed zoning district. As I mentioned, the proposed CC district is the only conventional district that is consistent with that PIRD future land use map classification. The site is large enough to support the permitted uses of the CC district, as it is nearly 42 acres. And again, the linear frontage along Pine Island Road is about 1,500 linear feet. So it can accommodate that kind of traffic. Other zoning district options, CC and PUD are the only zoning district options for the property, given the Pine Island Road future land use map designation. So in summary, the proposed rezoning is consistent with the goals, objectives, and policies of the Cape Coral Comprehensive Plan. It's compatible with the existing development pattern along that corridor for the commercial corridor district within the Pine Island Road District. It's consistent with the Pine Island Road District Master Plan, and it prepares the city for future growth, and we're requesting that you recommend approval to the City Council for the requested zoning petition as recommended by staff.
Thank you very much. I have no questions.
Thank you.
Okay, Mr. Boyko, thank you.
Good morning, Madam Hearing Examiner, once again. Chad Boyko with Principal Planner with the City's Planning Division. Before we begin, I would just ask that you recognize me as an expert witness based upon previous testimony and my credentials that can be obtained with the City Clerk's office.
I will recognize you as an expert based upon your credentials on file with the clerk's office and also based upon your testimony regarding matters that are, regarding issues that are not dissimilar to what you're discussing today, testifying to today. While we're addressing some housekeeping matters, do you wish to incorporate your staff report?
I do, yes.
All right, thank you.
All right, before you this morning, we have RZN 2229. This is a privately initiated rezoning application. There are two applicants for this. You have Honch LLC. They've got 3 different iterations of their LLC through each of the three parcels they own within this site. And then the other 2 parcels are owned by Lee Memorial Health System. The location is south of Pine Island Road and east of Veterans Parkway. It's a little over 41 acres in size. It has utilities with city sewer and the potential for water being serviced from the Greater Pine Island Water Association. So therefore, the site is within the Urban Services Transition Area. And then the applicant's request is a rezone from a Lee County zoning designation to the Commercial Corridor zoning designation. It was mentioned in the sort of the write-up to this that this is the 3rd step for full entitlement of the property to go along with the City of Cape Coral standards per the comprehensive plan. This was done anytime you annex property into the City of Cape Coral, it retains the Lee County future land use and zoning designation until it is changed by that municipality. So this is that 3rd step. The land use has already been changed to Pine Island Road District, and now they're seeking to change this to Commercial Corridor. The site itself, as you can see on the aerial here, you've got 4 sort of undeveloped wooded lots. You have 1 parcel that is kind of in the middle of those undeveloped properties that is developed with sort of a contractor business. There's a bit of surrounding development to the south. You have the Cape Royal single-family housing subdivision. To the north, across Pine Island Road, you have a scattering of large-scale commercial, such as Publix. You have what used to be sort of like a storage center that has now been cleared, and they are building multifamily on that property. To the north, that is just east of the Publix shopping center. You have some scattered development to the north of Pine Island Road as well, and then a little further ways to the east, you have the Sandoval's community, which includes a multifamily out parcel on the frontage of Pine Island Road, and then a bunch of single-family homes that's located to the southeast. The existing zoning of the site, as you can see here, it has Lee County designation, indicated by the gray on the map in the left. Surrounding zoning is Lee County to the south and to the west, and then to the north and to the east you have Commercial Corridor zoning, and then the proposed zoning would kind of fill on that Commercial Corridor zoning along these 5 parcels. We mentioned earlier that it's 5 parcels totaling a little over 41 acres. We mentioned how it's developed with a contractor business on 1 parcel and the rest is undeveloped. It was annexed into Cape Coral last year, and then the land use was changed by the City Council to Pine Island Road District in 2023. And we mentioned that this was the 3rd and final step to allow for commercial or mixed-use development.
Was that in March of 2023? I think that's what the applicant's rep said.
Yes,
Okay, thank you.
correct. So we analyzed this per our land development code. There are 6 standards that dictate how we would view and analyze rezones. The first is whether the proposed district is consistent with the comprehensive plan, and staff finds that the proposed CC district is compatible with the Pine Island Road Future Land Use designation. It is the only district that is listed as being compatible with the PIRD designation, other than applying for a planned unit development rezone. The second standard is whether the full range of uses allowed in the proposed district will be compatible with the existing uses in the area under consideration. The CC district allows for commercial, office, service uses, light industrial with some restrictions, and then also multifamily with restrictions as well. The area to the north is commercial. You have the storage use. You also have some other uses there to the north that are commercial. There are residential uses, single family to the south, and then multifamily to the east. Rezone would be similar district for sites with frontage on Pine Island Road. All along the Pine Island Road corridor, you have a mix of multifamily and then commercial, retail, industrial-based services. So the uses that would be allowed within the CC district would be fully compatible with the plethora of uses that you have located along Pine Island Road. Additionally, staff notes that the Commercial Corridor District does provide for buffers for the residential areas that are located to the south and to the east. The third standard is whether the range of uses allowed in the proposed district will be compatible with the existing and potential uses in the area under consideration. We mentioned earlier some of the north is commercial, but converting to multifamily. Most of the residential uses that are there are already currently built out. There is some undeveloped land that's to the north of Pine Island Road. There hasn't been any development that has sort of been proposed to us at this time, but staff predicts that the uses that will be built along this site will be compatible with the uses that would be proposed on those areas to the north, based upon that they're likely to be commercial or mixed use, or some multifamily as well, and those are the similar uses that you'll see being developed on this site. We mentioned earlier that there are certain buffers required by the LDC that would help protect some of the residential from any commercial uses that are built upon this property. The fourth standard is whether the proposed district will serve a community need or broader public purpose. The city has a well-documented need for non-residential lands, and also for multifamily development, we put workforce in because we expect that the new studies that we are conducting in terms of the need for multifamily will probably say that we are pretty good on the market rate multifamily, but we are still in need of sort of workforce housing that has sort of a lower price point for the residents of Cape Coral. And then staff notes that the commercial corridor zoning district will not allow for single-family homes or duplexes. The city is well stocked with single-family homes and undeveloped lots that you could build duplexes and single-family homes upon.
Do you know when that analysis will be available?
They are going out for I believe they haven't selected a firm yet for the multifamily study, but once the firm is selected, then you're probably looking at around 6 months to have that information returned back to us.
And will that be under the planning staff or some other?
We always contract that out to have someone do update the site for us.
I'm sorry, it wasn't clear. Will the planning staff be shepherding that through, or will it be another city department?
Correct, yes. It'll be the planning
folks.
division.
Okay, thank you.
The fifth standard that we have is the characteristics of the proposed rezone area are suitable for the uses permitted in the proposed district. We mentioned earlier that it's a fairly large site, 41 acres, with frontage on a principal arterial roadway. The site, the rezone is an assemblage of 5 parcels, so you do have some aggregation of land there. You have sufficient depth and width to allow for quality development, and then staff notes that Pine Island Road corridor is an ideal place for commercial and mixed-use development due to the frontage, the high classification of the road, and the number of trips that you see currently throughout Pine Island Road on a daily basis. And then the last criteria that we have is whether a zoning district other than the district requested will create fewer potential adverse impacts to the existing uses. As staff notes that the only other district allowed within this PIRD land use is the PUD zoning district, which is a wholly separate process that has many layers of review and approval that go along with that. So the CC is sort of like that most appropriate district. We also looked at this per our comprehensive plan with Chapter 4 Policy 1.15, which is the corridor siting criteria. There's a number of questions that go through this and to see if the site is appropriate for the commercial corridor. The site doesn't abut any properties already zoned or developed with CC zoning. It's adjacent to sites with CC zoning, but it does not fully abut them. And part of that is due to you have some roadways to separate the site from the adjacent parcels. Does the property abut corridor zoned area on 2 sides or more? No, it does not abut, but it is adjacent to CC zoned parcels on 2 or more sides. Is the property part of a large tract, a portion which is already zoned corridor? It is not, as this was a portion of a property that was recently annexed into the city of Cape Coral. This is a large lot assemblage of 3 or more acres, and the property does have more than 180 feet of frontage along Pine Island Road. It has approximately 1,400 feet of frontage along that roadway. And through our analysis of the comp plan and the LDC, planning staff recommends approval of the rezone to commercial corridor. And I'm here for any further questions.
I do have a question. It seems to me, can you go back to the last slide, please? Thank you. Excuse me. It seems to me we have a conundrum here because the comp plan talks about criteria, and it looks like this property or the proposed rezoning only complies with 40%. It doesn't comply with, it complies with 2 of the 5 criteria. Now, I don't believe the comp plan requires that all 5 criteria be satisfied, unlike some of the other matters that we deal with in zoning or in other applications herein. But in the alternative, other than a PUD, the requested zoning is the only zoning that would comply with the future land use. So it seems to me we have a a problem here, and since you are an expert, I know from other conversations with you, you're very familiar with conundrums in the city. I'd like your opinion about how we reconcile those two.
Well, I think there's two things to kind of weigh in when you look at the comp plan standards for this. One is that probably when the comp plan sort of came up with these corridor siting criteria, it may not have contemplated annexations coming into play for this area. As you know, sort of Pineland Road, we've been sort of filling in some of those donut holes per the, we have a bunch of enclaves that are out there, and the state does recognize that they want us to eliminate as many enclaves as possible. So with that, these setting criteria, which, I mean, they were done around 14, 15 years ago, maybe when there wasn't a lot of interest in people, doing voluntary annexations in the city of Cape Coral. So the comp plan standards did not get sort of updated at that time to perhaps weigh into all of the annexations and those properties that may want to come into the city of Cape Coral at the moment. The second, I think, is really just sort of like it's a semantics issue. We talk about adjacent and abutting. I think if you changed some of these standards to include, is it abutting or adjacent to properties that are already zoned commercial corridor, you would find that it would meet a few more of these standards and have more sort of like a concrete proof. But since, you can't, if you can be surrounded on all sides with commercial corridor zoning, but if you have roadways separating you, which you have Pineland Road that's almost always going to be to the north, that eliminates one area where you would be abutting. And then if you have access roadways on the other side of you, which obviously you need, then again, you're going to eliminate that sort of criteria of being abutting. But we try to couch some of this analysis saying that while it may not be physically abutting, it is still adjacent, which we can kind of consider as meeting some of those standards, even though the language in the comprehensive plan standards sort of solely address does it abut properties. But really, abutting or adjacent, from a practical standpoint, there's not a lot of difference in the two of those.
Well, in criteria 2, where it talks about 2 or more abutting corridor zone area on 2 sides or more, recognizing that you've testified that it is adjacent, I think you're on criteria 1. Criteria.
At the bottom, it talks about does the property abut corridor zoned area on 2 or more sides.
Okay, well, in reading the staff report, I think it abutted on 1 side, but not 2. So would that, if I'm remembering that correctly?
Yeah, it could be a typo. If maybe it was as staff sometimes we adjacent and abutting kind of gets, so it does not actually abut any properties zoned corridor if you want to talk about the Sandoval roadway being zoned corridor, I mean it is a private right of way. If you want to consider that as its own parcel, then it would be abutting that right of way that's zoned that way. But in terms of actual real property that is developed with vertical uses, such as residential, multifamily, residential or commercial, it doesn't abut those types of properties.
I think our assistant city attorney wants to weigh in. Would you identify yourself, please?
Good morning. John Niclario, Assistant City Attorney. I think Chad made a good explanation. As the hearing examiner suggested, the code and the comp plan does not require that all factors are met, unlike some other standards.
Or any of them, in fact.
Well, several are met, correct. And I believe staff, as they suggested, there are typos, I think, in this staff report, because you are saying that it abuts a corridor zone property, and then you say it's adjacent up there, so
Yeah, it could be.
Actually, I think at the last minute, he just offered some evidence that it does abut property. I think he said that there is a commercial corridor zone. It doesn't talk about the type of property.
It's a right-of-way.
Correct, yes.
But it's a commercial CC zone property?
It could, yes, it could be,
So
in
if
fact,
we're
the
playing
staff
with
report.
words,
Right.
and we're talking about abutting, it talks about abutting CC zone parcels. It
Thank
doesn't
you.
talk about the type.
Thank you. I appreciate your input, as always. And the other thing, it's sort of interesting, and I agree with you, is where it talks about criterion 3 is a property part of a larger tract, the portion of which is already zoned corridor. I think when we're dealing with these enclaves, I think that criterion can't possibly be implemented.
Yeah, that would be, I mean, it's entirely possible that we probably as staff need to revisit some of these criteria to account for these annexations that come in, obviously, if you're dealing with a brand-new annexed piece of property, it's not going to be a portion of something that was already zoned corridor. And, like I said, these were done 15 years ago when the Pineland Road District was first implemented. And it could just be that they're sort of outdated in terms of what we are seeing now in terms of property that are coming into Cape Coral. You're not going to find a lot of property 15 years later after the implementation of this land use and this zoning district where there's not property that's kind of hanging out there that's just waiting to be zoned corridor. If it's in the city and it's along Pineland Road, more likely than not, I don't want to say 100% certainty, but more likely than not, it's already going to be zoned commercial corridor.
Because of that huge effort you did a couple of years ago.
Yeah, and some of these standards were done as well when we used to have two zoning districts for Pineland Road District, the village and the corridor. So you may be seeing sort of some remnants of the thinking from back then when you were debating whether or not you would want to site zone the village or corridor. So there could be some inconsistencies there.
Well, and I'm sure you could put that towards the end of your very, very long list of things to accomplish in the next 10 years, 5 years? 2
Correct.
years? So I understand how busy planning staff is, but it's an interesting dilemma. I don't know how obviously it's beyond the scope of this hearing to discuss application of this in any future hearing, but it is an interesting thing to contemplate. But thank you for your testimony. It's very helpful. I appreciate it. All right. This is a public hearing. Are there members of the public who wish to provide input or testimony? Seeing none, I'll bring it back to the applicant's representative. If we can have you up, please. Ms. Fisher, thank you. You've heard a rather brisk discussion regarding the comp plan, and of course there's another element of the comp plan that applies, which you've articulated as well as Mr. Boyko has, which is our choices are a PUD or what you're requesting today. So with that firmly in mind, do you have any other testimony regarding these criteria that don't seem to be a really good fit today?
No, I don't have anything else to add for testimony.
All right, do you wish to incorporate Mr. Boyko's testimony into yours today?
Yes, please.
All right, anything else you'd like to testify to?
Nope, I appreciate your time.
All right, thank you for coming in. Mr. Boyko, we're done? Okay, thank you. So I will recommend that the rezoning go forward as indicated. I will incorporate some of the testimony today regarding these criteria, understanding that the criteria are not mandatory in the analysis, unlike what we have in some other situations. I will recommend it go forward as requested. I will attempt to get the recommendation out as quickly as possible. As I've indicated before, time is money. I'm acutely aware of that, and I appreciate everyone's testimony today. With those comments, I'm closing this hearing, moving on to the third hearing. Thank you.
VAC 22-000033, address 6 Burnt Store Road North, 16 Burnt Store Road North, 5 Northwest 32nd Place, and 13th Northwest 32nd Place. Applicant multiple owners. 3 property owners owning 4 sites request to vacate a portion of a 20-foot wide platted alley and underlying easements between lots 1 through 8 and lots 65 through 72 in block 4127. These same owners also request to vacate platted public utility and drainage easements adjacent to the platted alley in lots 1 through 8 and lots 65 through 72. The 3 owners collectively own 2.36 acres of land at the southern end of block 4127. The southern end of this block has frontage along 3 streets: Burnt Store Road to the east, Embers Parkway to the south, and Northwest 32nd Place to the west. All 4 subject sites, as well as all properties in block 4127, have a commercial professional future land use classification and commercial C zoning. The vacation of this alley will join 2 sites east of the alley with 2 sites to the west of this right-of-way. This alley vacation will facilitate property assemblage, increase the depth of the consolidated site, and increase the area of the site by 0.14 acres. The vacation of the platted easements will eliminate easements no longer necessary, as the consolidated site will maintain a perimeter easement. The owners will provide a cross-access easement to allow vehicles traveling in this alley in the future to exit onto Northwest 32nd Place. Concurrent with this vacation application, staff is reviewing a site development plan for a self-service storage facility on this site. This application meets city standards established for vacation requests and is consistent with applicable policies appearing in the comprehensive plan. Planning staff recommends approval of these vacation requests with conditions. Any person giving testimony today, if you are able, please stand and raise your right hand. Do you solemnly swear or affirm to tell the whole truth and nothing but the truth? Thank you.
Thank you, Madam Clerk. Good morning, Mr. Struve.
Good morning, Madam Hearing Examiner. For the record, Mike Struve, Planning Team Coordinator with the Planning Division. Staff did advertise this case, and that included placing an ad in the news press 10 days in advance of this hearing date, sending out letters to all property owners within 500 feet of the subject properties, and then posting a sign on the subject property as well.
Thank you. I will find the proper notice was given. Do you wish to incorporate your staff report into our discussion today?
Yes, I do. Thank you.
Thank you. All right. Before the applicant's representative begins, I'd like to make a few comments. First of all, I am very, very, very pleased that we have such a good turnout today. Citizen input is absolutely critical, and if you're familiar with how these hearings are run, I am an advocate of citizen input. And as I indicated in my opening remarks today, I don't have a 3-minute limit. I'm happy to listen to you as long as you wish to testify today. If you've not signed up to testify today, that's okay. You can still testify. If you've not been sworn in to testify today and you decide during the hearing you wish to testify, that's okay too. Our clerk will swear you in prior to your comments, but all your comments must be under oath, otherwise I can't consider them. And as I indicated before, please do not speak out from your seat, because I can't consider anything you say from your seat. The other thing I want to say is my jurisdiction is solely as to the vacation today. I do not have any jurisdiction over the future use of the property. Depending on certain pieces of the puzzle here today, I may or may not in the future have some type of a hearing on that. I don't know. That's totally outside of my world. But I know that I've received a number of comments by email, and as well as the poll that was taken, and thank you for that. And the use of the property, I'm happy to listen to you, but that is not something that I can comment on or provide a recommendation on. The last thing I want to say is that the function of the hearing examiner in these types of situations is to make a recommendation to City Council. This is not the final stop on the journey of this vacation. City Council is, and I would urge you, if you so wish, to pay attention to the City Council agendas, and if you wish to testify before City Council, they are the ones that make the final decision. It is deliberately intended this way so that the people that you elect are the people that make these kinds of decisions. So with those preliminary comments, can we have the applicant's rep up, please? Thank you. Good morning, Ms. Miller.
Good morning, Linda Miller, Vice President of Avalon Engineering, representing the property owners on this vacation of plat. So it's vacation of plat number 22-33. It has multiple owners. All of them have signed on the application to be an applicant in this process. At this time, I would like to be recognized as an expert witness for similar testimony that I have provided in similar cases, and also my credentials on file.
I will recognize you as an expert on the subject matter we're discussing today, based upon your prior testimony regarding issues that are similar to what are under consideration today, and secondly, based upon your CV, which has been received in the past. Thank you.
Thank you very much. So this vacation of plat is requesting approval to vacate 6,235 square feet of a platted alley and the underlying easements within that alley between lots 1 through 8 and 65 through 72 in Block 4127, Unit 59. We're also requesting to vacate the 6-foot public utility easement that is adjoining the alley on the east and western sides, and those total 3,741 square feet. The site is located at 16 Burnt Store Road North and Northwest 32nd Place. As you can see from the aerial, we do have several houses on this block. This whole block is commercial, but there is some houses that have built on the western side of the alley, just north of our site. As I just mentioned, the site is zoned commercial. The entire block is commercial. The land use is commercial professional. We are across the street from residential zoning, which is single family and single multifamily. We're also across the street on Embers with the same kind of zoning district, and across the street on Burnt Store Road with residential zoning. This entire block has been commercial professional for quite some time. Just to let you know that we do have utilities on Embers. That was part of the North 1 area, and so there is utilities for us. The rest of the lots that front on Burnt Store Road are in the next expansion area, North 3. So the application was submitted for this vacation request, and it meets the minimum requirements and standards set up in the Land Development Code Section 3.4.5. And those are: the owner is eligible to file a vacation request if the application provides the following. They have to have color of title or ownership of the site, which is the applicant has provided all the signature sheets from all of the owners and even a new owner that has taken ownership during this plat process. We have received letters of no objection from CenturyLink, Comcast, and Lee County Electric. Lee County Electric requires a continuous 6-foot wide perimeter easement around the site, which we will be providing. We've provided the actual survey sketches and legal descriptions to describe the alley, the right-of-way, the underlying easements within the alley, and the 6-foot public utility and drainage easements adjoining the alley. Those have been provided and accepted by the city. We've also provided a cross-access easement, which I will show you in another slide. So the applicant requests approval of 3 vacation requests here. One is the vacation of the alley and the underlying easements within the alley, and those total 6,235 square feet. The alley is 20 foot wide by 312 feet long. This alley lies in the middle of lots that front on Burnt Store Road and lots that front on Northeast 32nd Place. This restricts what you can build here. The city's land development code suggests that you have depth of 250 feet. Well, the lots on Burnt Store Road are 155 feet. The lots on the local street are only 125 feet. So vacating the alley provides for full depth development of the site. The next vacation we're requesting is to vacate the 6-foot wide public utility and drainage easement on the west side of the alley. And this alley, this easement vacation is 1,868 square feet, and it's between lots 1 and 8. That 6-foot wide easement goes for 311 feet. Our third vacation is to vacate the 6-foot public utility and drainage easement on the east side of the alley near the rear of lots 65 through 72. The easement is 6 foot wide and 312 feet long and contains 1,872 square feet. We are providing a cross-access easement that would go from Northwest 32nd Place and to the existing alley that we are not vacating. There will be a remaining part of the alley that will not be vacated through the rest of the block to the north. We are providing a 20-foot wide access easement. So in the Land Development Code, Section 3.4.5, it states that the vacations shall be reviewed in accordance with the following criteria, and there's several of them. The first one is whether the plat, easements, or right-of-way are required by the city for any future transportation, access, water management, or public utility purposes. Per the city's staff report, the alley right-of-way, the underlying and adjoining easements proposed to be vacated are not needed by the city to meet future transportation, utility, or drainage needs within Block 4127. Number two, whether any required easements are necessary to accommodate the vacation of the plat or the right-of-way. There is an easement that will be required. We have to provide a cross-access easement that will be provided for the continuous use of the alley for future commercial developments to the north of the subject property. Number three, if alternative routes are required or available that do not cause adverse impacts to the surrounding areas. An alternative route will be provided because we're providing the cross-access easement. I do want to talk a little bit about this alley. So this alley sits in Block 4127. It's located 150 feet from the intersection of Burnstore Road and Embers Parkway. So that doesn't meet the FDOT standards for a driveway to be located there. It doesn't meet the city standards for a driveway to be located from an intersection of a local street. That requires 150 feet. So we're on a major city roadway, Burnstore Road, and a major Lee County roadway, Burnstore Road, and a major city roadway, Embers Parkway. That alley would not be able to be used as any kind of driveway as it was originally planned when it was platted. So the Transportation Department has mentioned that in their staff report that we cannot have a driveway off of that alley. So vacating the alley actually is a good thing for the city. Number four, if closure of the right-of-way negatively affects areas utilized for vehicles to turn around and exit an area. And then here again, I said the closure of this right-of-way will not negatively affect as the alley where located does not meet the city or FDOT driveway spacing requirements for Burnstore Road or meet the distance between a driveway and a local street northwest 32nd Place. The city transportation would not permit a proposed commercial development to utilize the alley as their driveway connection to Embers Parkway. Number five, whether local utility providers have given consent to the vacation of the plat, easements, or right-of-way. And we've contacted all of the utility providers. They provided a letter of no objection. We have no utilities within the alley area to be relocated, and Lee County Electric is requiring a 6-foot public utility easement around the perimeter of the site. We accept the staff reports, the Planning Division case report, and we accept the requested conditions within that report. There are 6 of them. I will let Mike go through them, but we have no issue with any of these conditions. This vacation request will unify 4 sites currently separated by a platted alley, providing for full-depth commercial development. This application is consistent with Policy 1.15 and 3.6 of the future land use element of the city's comprehensive plan and was submitted in accordance with Section 8.11 of the city's land development code. Please accept into evidence the vacation of plat application, the supporting documentation, this presentation, the Planning Division's case report, and the staff's presentation. And I stand by to answer any questions you may have.
Thank you. I have no questions at this time. Good morning again, Mr. Strube.
Good morning again, Madam Hearing Examiner. For the record, Mike Strube, Planning Team Coordinator with the Planning Division. Okay. And Madam Hearing Examiner, for the purposes of this hearing this morning, I would like to request to be recognized as an expert in the area of land use planning based on my credentials on file with the City Clerk's Office and my past testimony previously before you on similar matters.
I will do so based upon your testimony regarding matters that are similar to the issues under discussion today, and also based upon your CV of record with the Clerk's Office. Thank you.
Thank you. This case before you today is a privately initiated vacation request. 3 property owners involved, involving 4 separate sites currently. The request before you, the owners request to vacate alley right-of-way and underlying easements between lots 1 through 8 and lots 65 through 72 in block 4127. This block, as you already heard, is located near the intersection of Burnstore Road and Embers Parkway. The other vacation request, the owners collectively request to vacate public utility and drainage easements adjacent to the alley, so this is on private property, also on lots 1 through 8 and 65 through 72. All 4 of these sites that are subject to this vacation request are located at the southern end of block 4127. This is an aerial map showing the 4 subject sites that are outlined in blue. All 4 sites are currently undeveloped. If you look at development patterns both within and outside of 500 feet of these subject properties, development consists mainly of scattered single-family homes, although farther away from 500 feet to the south, there is some multifamily development. This is a zoning map. The subject properties, as well as all properties in block 4127, have a commercial professional future land use classification and C or commercial zoning. Sites within 500 feet of the subject properties include properties with C zoning, single-family residential zoning shown in yellow, and NC zoning shown in sort of a light lavender color. The petitioners in this case own 4 sites that total a little over 2.3 acres. As I mentioned earlier, all sites are unimproved. There is a 20-foot wide platted alley that separates sites on the east and west sides of the block. The alley is unimproved, and most people would not know that alley exists unless they were to look at a plat of this particular block. So there's nothing visually that really indicates that there's an alley present in this block at this point. The alley right-of-way and underlying easements are requested to be vacated. In addition to that, platted easements next to the alley on the petitioner's sites are also requested to be vacated. We've reviewed the application submitted by the petitioners for compliance with our minimum standards and found that they've met our 3 standards for vacation applications, and that includes demonstration that the owners own the sites for which the vacations are sought or they have color of title. We've received correspondence from the utility providers in this case, and we've also received sketches and legal descriptions for the alley and the underlying easements and the platted easements requested to be vacated, and those have been reviewed by our city surveyor, found to be sufficient. These next couple of slides visually show the areas that the applicants are seeking to vacate, very similar to what Ms. Miller showed earlier. This first slide shows the platted alley that is proposed to be vacated. The area of the easements is very similar, except it would not include the northern and southern 6-foot wide strip of land that would be retained to provide a perimeter easement around the site. And we have a condition of approval that speaks to that. These are also clipped from sketches that the applicant has submitted to the city for review, and this shows the platted alley the platted easements, that exist on each side of the alley on the petitioner's site that are requested to be vacated. And this shows a cross-access easement that would be granted to the city by the petitioners to provide access for any vehicle that might in the future be entering the alley and to provide an exit way out. Right now, this access easement is not needed because none of the alley is improved, so there is no traffic that's supported by this alley. Staff has analyzed this request with 5 standards that appear in the Land Development Code, Section 3.4.5B, and our analysis below contains recommended findings for the hearing examiner. And the first standard is whether the plat, easements, or rights of way are required by the city for any future transportation, access, water management, or public utility purpose. And our analysis here shows that the alley right-of-way is not needed for any public access. If you're looking at this 4-parcel site as a single site, this site currently has access along 3 streets: Burnt Store Road, Embers Parkway, and Northwest 32nd Place. Burnt Store Road, as Ms. Miller mentioned, is a street that is maintained by Lee County, so the city does not issue driveway permits for development along Burnt Store Road. It is a controlled access road, so it is a little unclear which, if any, properties in this block would be granted driveway access when they are developed along Burnt Store Road. That being said, this site does have a pretty substantial amount of frontage along Northwest 32nd Place. That's a local street. Our driveway siting standards there are more permissive there, and based on the amount of frontage along that local street, a project on that along that street would at least get 1 driveway, and more than likely 2, given the length of frontage along that local street. So the alley is not needed to provide access for any of these 4 sites currently, given the location of the other streets and the frontage along the other 2 streets. The alley segment being vacated is also not needed currently for service or emergency management vehicles because it is unimproved, and likewise, those types of vehicles, if they're needed in the future to serve the site, would have sufficient access from one of the other 3 sites. The easements underlying the alley will not be needed. The city does lack infrastructure within the alley, and the platted easements abutting the alley are not needed. And as a condition of approval, the city would be retaining the upper and lower 6-foot wide easement underlying the alley to provide a continuous easement around the 4-parcel site, and we do have a condition of approval that I'll read into the record later that covers that. The second standard is whether any required easements are necessary to accommodate the vacation of any plat, easement, or right-of-way. I think we looked at this a little bit differently perhaps than the applicant. No new public utility or drainage easements are needed in this case, as the city would be retaining easements necessary or sufficient to provide for a perimeter easement. There certainly is a cross-access easement, however, that will be granted to the city to, again, allow traffic potentially entering the alley in the future to exit out onto Northwest 32nd Place. The third standard is, are alternative routes required or available that do not cause adverse impacts to the surrounding area? In this case, the vacation of the alley will not limit access of any property, any of the 4 properties covered by this vacation. It will also not limit access to any properties within the subject block. So alternative routes are not needed. Each site within the subject block has frontage on at least 1 public street, and that will not change if this vacation request is approved. Fourth standard is, will the closure of a right-of-way negatively affect areas utilized by vehicles to turn around and exit an area? And we find that the answer to this is possibly in the future. Right now, the alley throughout the block does not support vehicular traffic, so that cross-access is not needed, but we don't know what's going to happen in the future. And it's, since the entire block has commercial zoning, and since we do require off-site improvements, which includes alley improvements when commercial properties are either developed or redeveloped, it seems likely to us that at some point in the future, the alleyway north of the subject properties will be improved. And with that in mind, we are requiring a cross-access easement to be granted. So in the event that that alleyway is improved north of the site and extending down to this 4-parcel site, there will be a way for those vehicles to exit out to the west to that local street. The fifth standard is whether the local utility providers have given consent to the vacation of the plat, easements, or right-of-way. All 3 utility providers have issued letters stating no objection to the requested vacations, although there are some stipulations involved. 6-foot wide easements on the north and south ends of the alley will be retained by the city to provide a continuous perimeter easement. Staff finds that this request is consistent with a couple of policies that appear in the comprehensive plan, and particularly in the future land use element of the comprehensive plan. The first policy is 1.15, Table 1. This table shows which zoning districts are consistent with which particular future land use classifications. And in this case, the commercial zoning district is consistent with the commercial professional future land use classification. Policy 1.15C, this standard provides guidance for the commercial professional future land use classification, and it's a fairly long standard, but what is particularly, I think, germane in this case is that this policy for C-zone sites advocates that properties with C zoning have frontage along 2 major streets, which this 4-parcel site does, Burnt Store Road and Embers Parkway, so it's consistent with that standard. There are certainly other properties in the city that don't have frontage on 2 major streets, and some C-zone properties that don't have frontage on a major street to begin with, but this describes sort of the ideal situation. Likewise, the same is the case with full block depth. This particular standard advocates that C-zone properties have full block depth, which this 4-parcel site would have should the alley vacation be approved. And then the last policy is policy 3.6, and that states the city may consider the vacation of rights-of-way to facilitate land assembly and the development of a unified contiguous commercial project. What this vacation would do is that it would remove, in our view, an unnecessary right-of-way. It would unify these 4 sites, allow them to be combined together, which would offer several benefits. It would provide more flexibility in developing that site in the future. It would slightly increase the area of the site, would provide for full block depth, add a very, very, very small amount of land back onto the tax rolls, and would, in a very small way, lessen the city's future maintenance obligations as well. Staff recommends approval of these vacation requests with conditions, which I'm about to read. I did want to report on the correspondence that we've received before I move forward. We have received 1 phone call and several emails. We've received 1 phone call and 1 email that were just from individuals wanting additional information about this request, And then we have received 6 emails in opposition to this request. Some of the emails were rather specific in terms of a potential use that they envisioned being developed on the site, and were less about the vacation itself. You have copies of all the emails except for one that came in most recently, and I do have a copy of that for you as well, and for the applicant too.
Thank you, I appreciate that.
And now just going over the conditions of approval, there are 6 conditions of approval. The first is the owner shall be responsible for all costs associated with relocating any utility provider facilities occupying easements affected by this vacation. The second, the vacation of the alley and underlying easements located between lots 1 and 8 and lots 65 and 72 and block 4127, Unit 59, Cape Coral subdivision shall be consistent with that shown in the sketch and accompanying legal description prepared by Philip M. Mold entitled Proposed Vacation of a Portion of Alley and any and all underlying easements in Block 4127, Cape Coral, Unit 59, dated June 2nd, 2022, as shown in Exhibit A. The third condition, the vacation of the platted easements located in lots 1 through 8 and lots 65 through 72 in Block 4127, Unit 59, Cape Coral subdivision, shall be consistent with that shown in the sketches and accompanying legal descriptions prepared by Philip M. Mold entitled Proposed Vacation of a Portion of a Public Utility and Drainage Easement lying in a portion of lots 1 through 8, Block 4127, Cape Coral, Unit 59, and proposed vacation of a portion of a public utility and drainage easement lying in a portion of lots 65 through 72, Block 4127, Cape Coral, Unit 59, dated June 2nd, 2022, as shown in Exhibit B. The fourth condition, within 90 days from the date of adoption of this vacation, the owners of lots 8 and lot 65 shall provide the city with a perpetual cross-access easement on lot 8 that provides a vehicular connection between the alley and Northwest 32nd Place. The cross-access easement shall be consistent with that shown on the sketch and legal description prepared by Philip M. Mold entitled Cross-Access Ingress Egress Easement in a portion of Lot 8, Lot 65, and a portion of a 20-foot alley, Block 4127, Cape Coral, Unit 59, dated November 30th, 2022, as shown in Exhibit C. This easement shall be approved by the city land development manager and the city property broker prior to execution. Condition 6, the owner shall pay to the city of Cape Coral the cost of recording this resolution with the office of the Lee County Clerk of Court. And then 6, the city shall record this resolution with the office of the Lee County Clerk of Court following the receipt of the recording fees from the owners. That concludes my presentation. I'm available in case you have questions.
Thank you, I have no questions. All right, I'm opening public comment at this time. I have a request to speak from Ralph Huber. Mr. Huber, would you come up, please, sir? And I do want to acknowledge that you had sent an email with some attachments, but you're certainly welcome to testify as well. Thank you.
Yeah. Thank you for the time to speak this morning. I understand the intent of this hearing is not about what's going to be developed at this location. But I do question whether or not the notice to the surrounding property owners was properly distributed. I don't know what the 500 feet rule is. I know that I live within 1,500 feet of this proposed vacation request, and I would have wanted to know about this beforehand. So I did become aware of it through the neighborhood app and as a member of the Northwest Cape Association as their communications director. With 1,500 members, when they were provided this notice to property owners, it was a resounding no, we do not want to approve this vacation request. And I think the reason for that is that this notice to owners did not indicate, as it does in the agenda item, that the purpose of this vacation is for the construction of a storage facility, which is in the application phase now with the city. So had that been known in this notice to the owners, I think you would have seen a lot more people come out here to protest this application for vacancy. I also had a question about this document where it talks about, on the agenda item, where it talked about no impacted cost to the city. I would like to know whether there's an impacted cost of the city if the easement request is denied. I understand if it's approved, there's no cost to the city, but is there a cost if it's denied? And if it's not, no cost to the government, I think that we would like to ask that an exception or a condition of the application be added, that approval of the application would have the condition that development of a storage facility, a dollar store-like development, and a car wash be stipulated as not an acceptable development on this vacation property indicated in this agenda item. I did take the liberty of sending out this 500-foot notice to surrounding property owners, to all of the members of the Northwest Cape Association, and to the members of my own personal Cape Coral neighborhood app. 150 responses from the neighborhood app asked for this vacation to be denied. 575 members of the 1,500 strong Cape Coral Association asked for this vacation to be denied. And I also had a question about that this is in applicable policies in the comprehensive plan for the city. The comprehensive plan for the city was presented to the Northwest Cape Association in July by Wyatt Daltrey in the presence of the mayor, Councilman Long, several other councilmen, and the president of the Northwest Cape Association, who back then was John Basham. And our, presentation to over 250 residents of the Northwest Cape indicated that the comprehensive plan for development would not include those three types of developments in the Northwest Cape corridor on the Burnt Store corridor. Presentation had the vision and was going to become part of the department's development plan, or the city's development plan. I don't know what stage that's in right now, but at the time, that was phase one of that development plan. Understand that the recent moratorium on the development of storage facilities did not include this request that's in the North Cape because it was in 2022. But this easement offers the city the opportunity to keep to the spirit of the comprehensive plan and not let these sorts of development occur in the Northwest Cape corridor. Thank you.
Thank you, sir. I want to address the first point that you raised. I don't normally interact with people with public comment, but I do want to address your first comment regarding notice. The reason for the posting of signs on the property is to advise people who might not otherwise have received that 500-foot, the notice that is sent there and within that 500-foot. The theory is that you would drive past the sign, see it, and then have some inquiry made of the city. So I don't know, no system is perfect, but I believe that was the intention in that, of the requirement of the posting of the signs. With regard to your other questions, you can certainly call city staff after, or perhaps they may be available after this hearing. I don't know what their other commitments are today, but they may be able to share with you their knowledge regarding your other questions. But in any event, thank you for coming in. I saw that there were a number of other, I'm sorry, sir, I can't take any further comment from you, I'm sorry. Is there anyone else who wishes to testify? I saw a number of hands. The gentleman in the back in the, is it blue or gray shirt? Yeah, blue. That's you. Okay, come on up, please, thank you. Thank you for that reminder, I appreciate that. All right, sir, were you sworn in?
I swore in, yes.
Okay.
If you want to swear me in again,
All right.
put my name here.
No, that's fine. I mean,
Fine.
maybe after you get done. I'm sorry, what did you say your name was?
My name is David Basadre. I live at 5 Southwest 33rd Avenue.
You can talk from either one, but could you spell your name, please?
B as in boy, A-S-A, D as in David, R-E.
Okay, we're all set, thank you.
So can I use any of these slides?
Sure, and as a matter of fact, we'll give you a hand if you need help with that.
Yeah, I might.
Mr. Struve will give you a hand. He's pretty
Yeah,
handy with
okay,
that
so
IT stuff.
right here on this slide, it seems like both sides of that block are commercial. Right about where it says 500 feet mailing buffer, there's homes there. But yet it's orange or whatever color that is, commercial, but there's homes. So why did those homes end up there in a commercial property? Did they get, zoning come here and say, hey, I want to put residential on commercial? I don't know. Anyways, by allowing commercial, by allowing residential, you're setting precedents on that side of the road on 32nd Place that side will be residential. If not, you're doing spot zoning. This will be this will be that, this will be this. There's no consistency, is what I'm seeing. So it's either residential or commercial. So now 32nd Avenue, somebody can come next week, and there's some empty lots in between there, and say, oh, I want to do the same thing these guys did at the corner. I want to unite Burnt Store and 32nd, and now we're going to have another commercial component, but we're going to have residential homes stuck in between there. That's not, I think, the way you want to do this. You want to keep it consistent. Okay, if that's commercial, that's commercial. Shouldn't be any homes in there. And this is the way it is. But you're picking and choosing. Also, I get the feeling you guys are, missing the trees through the forest. That little neighborhood, I go all over Florida, see different areas. This is a clean slate. This is a nice area. If that's 7 islands, if they do half of what they're talking about, it's gonna be spectacular. And then that little property next to Burnt Store boat ramp, they wanna do something nice there too. And you wanna put another storage facility there. Homes down there are selling for $1.5 million, $1.8 million. A home just popped up, not too far, 2.7. There's a home right there for sale, 2.4 or something. This is going to be a super nice neighborhood. Brand new homes, brand new commercial, Publix, all that mall, beautiful. You guys did awesome. But that storage facility, you know, you just might as well throw 3 more car washes down the road there, and then we're full Cape Coral. You guys have a shot here to do something. This is gonna be a spectacular little area, different. I think you're shooting yourself in the foot with this one. And you gotta be careful, commercial component, you're so close to the residential, and you're mixing and matching down that block on 32nd. It doesn't look right. Do something nice. This is not nice, what they're bringing to the table. You know, you guys said, oh, we have access from major roads, it's perfect. You're missing it. You can't see the forest because of the trees here. So just step back and look at it. Don't read the words, look at it. What you guys are creating here. Do something nice. That 7 Islands gets done, it's gonna be spectacular. They're gonna do the little thing next to the Burnt Store boat ramp, it's gonna be awesome. Beautiful homes are being built there. It's a great little spot. It's not just any spot. And now's the time to do it right. If not, you're gonna own it for another 50, 100 years. That's what I got for you.
Anything else?
That's it.
Okay, thank you for coming in today and taking time out of your day to do that. I appreciate that, and I appreciate your comments.
I have one more question. That 500-foot radius,
Yes, sir.
not too densely populated. Maybe 6, 8, 10 homes maximum. Everybody in that radius here?
Sir, talk to me, don't talk to
Oh,
the
I'm sorry.
audience. That's okay.
So, what I'm saying, maybe there's 8 people, homes that got notified. I see a lot of people here. I'm guessing you got 100% turnout, not 6 emails. Oh, I got 6 emails saying no. No, I'm pretty sure you got 100% turnout. People coming here saying no to this.
Thank you. Mr. Huber did provide a table that had a significant number of opinions in it. So while Mr. Struve was correct about the 6 emails, one of the enclosures that Mr. Huber provided was a table with a large number of input from the neighborhood.
Okay.
Okay.
Thank you, ma'am.
And once again, thank you for your input. Yes, ma'am, in the pink. Thank you. All right, Madam Clerk, thank you.
Please raise your right hand. Do you solemnly swear or affirm to tell the whole truth and nothing but the truth?
Yes.
Thank you.
Thank you, Madam Clerk. You just state your name, please, ma'am?
Terry Fitzgerald?
Fitzgerald?
Fitzgerald, yes.
Fitzgerald?
Correct.
Yes, ma'am, go ahead.
So can I put that screen up that was just, yeah, this one?
This one? Sure.
Yeah, so I wanted to point out, and I realize this isn't a city council meeting, this isn't a zoning meeting. I'm here for the same reason everybody else is, and I agree with them before. I don't want a storage facility there. But sticking with what the purpose of this, with the vacation of that alleyway, what struck me was that Northwest 32nd Place would be where the driveway would go, because you don't know if you can do it from Burnt Store Road, you don't know if you can do it from Embers. That's waterfront property there. That's residential street. And so what I object to with being that this is the meeting for vacating the alleyway is that that would be the only entrance into this. Like the previous speaker said, there's houses selling there for over $1 million. We don't need entrance to a storage facility on that road. That's a residential road, residential neighborhood with waterfront properties. That's my spiel.
Thank you, and thank you for coming in today.
Thank you for having us. We appreciate it.
I appreciate you taking the time. Yes, ma'am, the lady in the other pink. Come on up.
I did not get sworn in either because I wasn't.
All right.
I really just have a question, but I'll do.
Do you solemnly swear or affirm to tell the whole truth and nothing but the truth?
I do.
Thank you.
My question would be, well, first off, there is a.
I need your name, sorry.
I'm sorry, Amy Hickel, Hickel.
All right, thank you.
So My first statement is we do have a storage facility within 1.5 miles of that location. So we're, again, piling all these crappy facilities in. But my question is, you had asked about, or someone had stated something about signs being up on the property. If that is a requirement, there has not been one sign. The only reason we knew anything, we don't live within the 500 feet, so we did not actually get any notification, but the only reason we knew was because of like next door and the Northwest Neighborhood Association notifying everyone that this 3-story storage facility, which to me is a monstrosity in a residential neighborhood, was coming in. So my only question or statement is, if signs are required on the property in order to get an approval on this, that did not happen. There has not been one sign notifying the public on that property what the intent is as far as this vacation or what the proposed facility is going to be.
Thank you. I'll have Mr. Struve address that, but thank you for coming in today, and thank you for testifying. Appreciate that. Yes, sir. Come on up. Were you sworn in, sir?
Yeah, I've been sworn in and I've been sworn out, so we're good. We're good.
I was waiting for somebody to say that. Could we have your name?
My name's Don Baressa. It's Bouressa.
Thank you, sir.
And I live just a little bit out of that 500 zone. Bought the house built 2 years ago. And at the time we bought, we weren't told that any of that was zone commercial. Not blaming you guys. But like what everyone else is saying, I can stand on Embers and look down 32nd Place and see a storage facility. It's going to be like bookends. It's going to be ugly, especially for any other projects in the area. I mean, when it was first designated zoned, I think they were talking about having a bank there, which would, if it's done nicely, it would look good. One other thing, can someone give me a definition of what professional commercial is? Because I don't think a storage unit is professional by any means. I mean, I'm a simple man, but you know.
It's the commercial side of the professional commercial.
Okay, but what is professional about a storage unit?
I'm not going to answer that question,
Oh,
sir.
I'm just saying, okay, then it's in the air. Well, I mean, there's nothing professional about it, nothing. And like everyone else is saying, I've got what the tax department is telling me, Lee County Tax. So I got a very expensive home. I didn't pay, all of a sudden they're telling me I got a very expensive home, but I can't sell it because it's all the zoning that's gone down that street. But I'm still paying huge taxes on it. It's ridiculous. You know, if we're going to do something like everyone's saying, do it right, make it nice, and allow the people that are there to enjoy their surroundings and have a beautiful surrounding. That's what we bought into. We didn't buy into storage units, car washes, dog washes, you know, things like that. Thanks.
Thank you for coming in, and thank you for your comments. Yes, ma'am.
I was not sworn in.
Okay.
Please raise your right hand. Do you solemnly swear or affirm to tell the whole truth and nothing but the truth?
Yes.
May I have your name, please, ma'am?
Good morning. It's Sean Dudek, Shaun Dudek.
Thank you, thank you.
And I'm on Second Terrace at 36th and Embers. I'm not in that 500, but I have lived through the construction on Burnt Store and Embers when they started shutting down the entrances and exits. So what we were addressing today was the alleyway, and very nicely put with the red in the alleyways that you want removed, but how you just made this one curve sheet that showed the alleyway that's going to be the new entrance off of 32nd. So what I heard was they could be 2 entrances off of 32nd Place, and then that new 20-foot alleyway that you want approved as this new vacation to come in. So that could be 3 commercial entrances on a residential street. moving trucks, boats, RVs, coming in to a residential neighborhood. Again, everybody's talking about the 7 Islands, and exciting to hear that. Heard about how wonderful it will be, the gateway off of Tropicana and Embers coming into that neighborhood. Those are the 2 major streets. And right now, you've just come in and made that commercial right there, understanding at the end of the block, it's going to have that. But we now have moving trucks, boats, RVs, whatever that storage unit's going to house, 3 entrances off of a residential street that are 1, 2, and soon to be $3 million houses, because no one knew, well, they might go back down to $1 million because nobody's going to want to buy with 24-hour lights on and a chain link fence around it. So please consider that the vacation where is the 20-foot alleyway, east and west. That's right next to, the one slide showed it, that's right next to a residential home. That's what that person will have, is a major drag street between, just as I think 4th came in when Embers was shut down, and just as 32nd became a major commercial drag street for every truck and every vehicle when they were building Burnt Store Road. Thank you for your time.
Thank you, and thank you for coming in today. I appreciate your comments. Yes, sir, in the back, come on in.
I haven't been sworn in.
Please raise your right hand. Do you solemnly swear or affirm to tell the whole truth and nothing but the truth?
I do.
Thank you.
Could I have your name, please, sir?
Raul Serra.
Yes, sir, thank you.
And I live right on the corner. I'm a couple houses down from that area. And my property is commercial. I mean, I'm 203 Northwest, 32nd Place. So my actual home, when I bought it in 2019, I had no clue that I was in a commercial land. When did this become commercial?
I can ask staff to address that question after the hearing.
Okay, and then, someone mentioned it earlier about, we do have homes in that area. Are we gonna have commercial properties with residential? Because I own the local Radio Shacks in town. Could I put a Radio Shack on my property and make it legal? I mean, because I'm on a commercial piece of, my neighbors are gonna hate me, but is that something that I would be able to make happen? And is it gonna be somewhere we're gonna have, homes turn into a barber shop or a pawn shop, because those homes are on they're on a commercial property. So, is that something that we could pursue or see in the future?
Once again, that's something I can have staff address after the hearing, or possibly, if you call in. I don't know if there are other commitments are, sir.
And then, the area is, my property, I'm taxed on residential, but I'm living on a commercial property. So am I being taxed fairly? 'Cause I'm paying a lot of taxes for my home, and I'm on a commercial piece of land. So, these are things that, and again, nothing, I live a couple houses down from the property that, the future storage, nothing, I had never saw any signs, nothing visible about what was going on there. And, I was told by my neighbors, and, and I think we have enough with one storage. The city of Cape Coral is a city that, when I came from Miami, I appreciated the city because they're strict on a lot of the zoning, and when you see future plans of a storage on top of a storage on top, because they're planning about 3 different storage locations within a half-a-mile radius. And then you have properties on waterfront properties that are over $1 million. The taxes that are being paid on these properties are substantial amounts, and we're piling up all these storage facilities on top of each other. I just don't think it's smart planning for our city, and then to have an alleyway with alleyway facing that waterfront community is just going to really depreciate and hurt the area.
Anything else?
That'll be it.
Okay,
Thank you.
thank you for coming in and for taking time out of your day, Mr. Sarah. Is there anyone, yes, sir, in the gray. Good thing I'm not colorblind, huh?
I've been sworn in. My name's Steve Olander, Olander. I live about 50 feet out of the circle on 32nd Place on the west side of the road. I have neighbors that live right across the street on me in the commercial zone. And a couple things I just wanted to point out is that when they redid Burnt Store Road, they were going to have it go across Embers. And they changed the plan on that, so you can no longer go straight across. So everyone to the left of on that picture that needs to go north has to come up 32nd Place over to Second Tear and then onto Burnt Store Road and then do the loop up to go north up to Punta Gorda. So by adding this alleyway, you're going to increase the traffic. Everyone going into that storage unit that's going north is going to be coming up 32nd Place, across Second Tear, down Burnt Store Road, doing the loop back up north. We don't have any sidewalks there, and we have some young children in the neighborhood. And also, we're going to be assessed with UEP in 2025 for about $36,000 to $50,000. And we really don't want to start paying for moving trucks and all this extra traffic to be beating up our roads. So I'm proposing this alleyway gets shut down. There should be no easement there. I think it's just a disgrace. So,
Anything else?
That's it.
Okay, thank you very much for coming in, sir. Anyone else? Yes, sir, come on up. The gentleman in the back, the gentleman in the white. I don't know, maybe it's beige. Depends on your laundry, I think. Were you sworn in, sir?
No, I need to be sworn.
Please raise your right hand. Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth?
I do.
Thank you.
Thanks for listening to me. Good morning. My name is Greg, G-R-E-G, Lysack, L-I-S-A-C-K.
Thank you.
My wife and I own property on Shadrow Lake. Shadrow Lake is on the corner of Burnt Store Road and Embers. We purchased this property over 30 years ago, hoping that one day we would retire here. 30 years ago, this area was very different. It was very rural. And progress has changed that. That's understandable. But in terms of progress, the one thing Cape Coral does not need is another storage facility. In my opinion, this does not represent progress. This is a blemish on an otherwise pristine area. It doesn't serve to enhance or benefit the surrounding community in any way. And you can put an end to that right now with this. That's all I have to say. Thank you.
Thank you, sir, and thank you for coming in today. And just to remind you, the city council makes a final decision. You said I can make an end to it today. I only make a recommendation. So you might want to go to the city council meeting and testify as you think appropriate.
Yes, thank you. I will, but thanks for listening.
Sure, of course. Thank you. Yes, sir. I'm not even trying to guess the color of that shirt. Were you sworn in, sir?
I was not sworn in.
Please raise your right hand. Do you solemnly swear or affirm to tell the whole truth and nothing but the truth?
I do.
Thank you.
May I have your name, please, sir?
For the record, Madam Dalton, I'm Hal Arkin. Been a resident of Cape Coral for 55 years. I started putting that property together 42 years ago, before Seven Islands. I envisioned that that was going to be a tremendous development, and it will be. But it is the city who changed the land use for Block 4127, 4128, and 4129 to land use, commercial professional, and zoned with the new commercial zoning. The property is a permitted use. I understand, like I said, I've been here a long time. Years ago, that property was residential. I knew that this is a major intersection and the highest and the best use would be commercial. Those homes that are there, those were done when they were residential. I empathize with the people that are living there, but people should know that the land use and zonings have been changed. Number 2 or 3, Burnt Store Road is a limited access road. There will not be any access on Burnt Store Road probably for another 7 years to 10 till they do the 6 laning. Then the 2 lanes that are there now will be a frontage road going up and down. I have 410 feet of property on Burnt Store Road. I cannot get an access. Another reason is that it is county-oriented, not Cape Coral. And it is going to be a DXL lane, so that's again not allowing my property rights to get to my property from Burnt Store Road. With the alley being vacated, we've already paid to have a lot of the utilities moved, and the city is not at this time recommending the opportunity for access from Embers Parkway, which means it limits my property to one driveway, and that's coming from Northwest 32nd Place. I believe that what is being done is to do something that the city has had the problem with platted lots. You have 125 feet frontage, an alley, 125 feet on the other side of the alley. This property here can potentially have 300 feet of frontage. And I believe that with the alley vacation is going to be an enhancement. I empathize again with some of the people that have purchased some of the property, but not knowing that the property in front of them is commercial. I believe that the idea of vacating this alley and future of getting frontage and depth will be an enhancement for commercial. Thank you.
Thank you for coming in and thank you for your comments. Is there anyone else that wishes to testify that has not already testified? There's a couple of you out there. All right. Seeing none, I'll close public comment at this time, bring it back to the applicant's representative, Ms. Miller. This is your opportunity to provide, I have no other questions, this is your opportunity to provide further testimony if you so choose.
Thank you very much for the opportunity. I do really appreciate the residents coming out this morning on this case. I do understand that they have concerns about a future development of this track instead of the actual vacation of the alley. And I'm happy to, since those plans are also public record, since we submitted them, and they're going through a review process, be happy to answer any questions that they have, provide any plans to them. They just need to call me or email me, and I'll be happy to answer their questions regarding a future development. But I have no other input. Thank you.
Do you have time today to address the folks that are here, or would you rather have it in another arena?
I can show them, I can provide them plans. I don't have the plans with me today because the vacation of plats don't require you to provide for development. A vacation of plat requires you to provide the documentation needed for the application process. But I would be happy to.
I was just thinking if they had questions in general, not.
Oh, yeah, sure, I can meet with them afterwards.
All right.
Thank you.
Thank you very much. Hang on, folks. No, not appropriate. Ms. Miller has indicated she's willing to meet people in the hallway?
Well, sure, I could do that, and I can give you my email address at that time and my phone number.
Thank you very much. All right.
You're welcome.
Thank you. Mr. Struve? I do have a question for you, Mr. Struve. A gentleman raised a question regarding the contents of the sign that was posted. Could you address what the requirements are for signs?
Sure. We're required to post at least one sign on this site. In situations like this, we usually place at least a couple, which I believe that we did in this case. Our obligation ends once we post that sign. We're not required to maintain that sign and check it daily to make sure that that sign stays up between when that sign is posted and the date of the hearing. Sometimes signs blow down. Sometimes people are upset with cases that are scheduled for hearing, and we've heard anecdotally that they take the signs down. So we've met our legal obligation in this case, just like in situations, and I'm going to analogize this a little bit, where we have sent someone a letter and they may not be living in Cape Coral, but may be living in Canada, but their mailing address says Cape Coral. We've met our obligation in sending them a letter. If they haven't updated their mailing address, that's their responsibility, not the city's. So I hope I've explained that adequately.
Could you address what's required to be listed on the sign itself?
Yes, so we're required to list information about the the case number, which we did, the type of case, the request, the time, place, and location of the hearing.
And the function of that is so that people can look on the city website for the hearing examiner hearing and get further information?
That is correct, and I believe we have a QR code or at least we used to, on our sign, so if someone wanted to take a photo of that, that should take them to more detailed information about the case, which would include the staff report and the application and all of the information that the applicant, in this case, would be required to submit to the city that staff has reviewed.
And because this is an application for a vacation of an alley right-of-way and associated easements and other easements, is there a legal requirement to list the proposed use of the property?
No, but I do want to touch on that for a moment.
Well, I'm done with my questions, so have at it.
Okay.
Thank you.
So we had included in our staff report that we had a concurrent application, that we were reviewing it, and I believe the city clerk also read that, and that was part of our summary. We didn't need to disclose that, but we did, and we did that intentionally because we want to be as transparent as possible about all applications that are before us that involve property involving some type of public hearing case. We think that's important for people to know. I know in some cases that may frustrate them, and it even may frustrate them to the point where they may not even want to know that information if they can't do anything about it at the hearing. But we think the more information people have about a property that's subject to a public hearing request, that's all the better for them. We think that serves a public interest, and it's up to an individual to do what they may in terms of learning more about what they can and can't comment on.
All right, anything else?
I also wanted to thank everyone that showed out today and commented publicly, and I also wanted to mention too, I realize that this can be not just cases before you, Madam Hearing Examiner, before the City Council. It can be a frustrating forum because I know people sometimes want to be able to ask questions of you or of staff. There's a reason why in our staff report, and also when we send out letters of notification, that we include staff contact information. We include our direct phone numbers, we include our work emails, and we certainly invite people, if they have questions about the case itself or the property or surrounding properties, that they contact us, and that allows us to have a more detailed and nuanced conversation with people.
Thank you, I appreciate that. I have no other questions. All right, I do want to note for the record that I've been provided with a number of emails. They appear to all be opposing the proposed vacation for one reason or another. And when I do my recommendation to the City Council, I will note the names are too voluminous today to take your time today to note that, but they will be in the recommendation. Oh, Mr. Naclerio.
Thank you, Your Honor. John Naclerio, City Attorney's Office. I just wanted 2 points, really. At the very beginning of the hearing, at your introduction, you indicated that a use is not a proper discussion during this vacation of plat. I'd just like to point out for the record that all of the criteria, the legal review criteria for a vacation of plat is established at 3.4.5 of the Land Development Code. The use of land is not one of the factors. And the only other point I want to make, I believe there may be a typo in one of the conditions. Condition number 4 talks about the cross-access easement. Within 90 days from adoption of this vacation, the owners of lots 8 and 65 shall provide the city a perpetual cross-access easement on lot 8. I'm looking at the sketch. It looks like the cross-access easement is also on 65. Was that inadvertently left out, or is that?
It's condition number 4, Mr. Struve. Proposed condition number 4, I should say.
Looks like from the sketch, it should be the easement encumbers lots 8 and 65.
Yes, I would agree. That was an unintentional omission, so we should include that to reflect both the owner of Lot 8 and the owner of Lot 65.
And I would ask if the applicant is in agreement and with that tweak.
Ms. Miller, come on up. Thank you.
Yeah, we're fine with that, thank you.
Anything else?
Nothing, Your Honor, thank you.
Okay, thank you very much. All right, having no further business before me regarding this hearing, I am going to close the hearing at this time. I want to review the emails in depth, which I didn't have an opportunity to do prior to today. I did read them, but I wanted to contemplate them. I also want to consider the comments that were made regarding the vacation of the alley and the easements. As I started out by saying, the use of the property is beyond the scope of what I can address. The reason why I thought about and decided to have you folks testify, even if you were testifying regarding the use, is twofold. First, you did take the time to take time from your busy days and your other obligations to come in, and I want to respect that. And secondly, this may be a forum that you can express those opinions. I do not know if you will have other forums to do that. So I genuinely appreciate the comments, even though the use is completely outside. If I made a recommendation regarding the use, it would be improper and would be ignored by anyone who is in a decision-making capacity. So I'm not going to address the use and won't address the use, but I do appreciate everyone coming in. I'm going to review all the comments as I've already indicated, and I will attempt to get my recommendation out as quickly as possible. That recommendation can be obtained from, I think it is staff. I don't really quite remember. Is it staff or the clerk's office, if you want a copy of it?
If they filled out the participation form, it says on the bottom if they want to receive a copy.
Okay, and so that's a good point. If you've not had an opportunity to fill out the participation form, which I always call a card, but in fact it's a sheet of paper, they're over there. If you'd like a copy of the recommendation, please fill one out and provide it to the clerk, and then she will make sure that you get a copy. And Ms. Miller has graciously agreed to spend a little bit of time out in the hallway to address questions. She doesn't have documents, but of course, because they'd be outside of our hearing today, but she can certainly address documents. I would urge everyone to, and I'm sure you will be respectful of her, because this is a purely voluntary act on the applicant's part. And so I know there's a lot of emotion with this situation. I understand that. And I appreciate you all coming, and I appreciate Ms. Miller's willingness to have an informal discussion with everyone. And she's indicated she will give her email and phone number for any future contact that you might need regarding the application. So with all of those comments, I'm closing the hearing on this particular case at this time. The date and time of our next hearing is Tuesday, June 20th, 2023 at 9 a.m. here in Council Chambers. We stand adjourned at 11:08. Thank you, everyone.